that okay? You getting, can you tell? Did that work? Working? Can they tell if it's working? Where should I put this? Oh. Otherwise, I'll be quiet. Does that work? Yeah. Yeah, I saw. Yeah, it's a nice picture. I'm going to take one of those home. Good. I remember Cy from because he came to that's where I met him. Was at the adjudicators. Yeah. Yeah. So are those all students? They look old. Right in the middle. The guy who was upstairs with the long Yeah. Oh. I know them from somewhere. Yeah, I think I do. Okay. Okay. Sure.
So welcome students. Welcome to our colleagues in the profession and on the bench, in particular Chief Justice Popescule and various members of the Court of Queen's Bench. Welcome to the first speakers event of this term. This is part of a special chair in advocacy, which was created in 2009 to honor the 50-year career of Halyk, who is also with us today. And it's just a pleasure to have him back to the college. Cy is one of Saskatchewan's most distinguished advocates. And I couldn't even begin to list the ways that he's celebrated as a lawyer and advocate here in the city, or in the province. He was a leading lecturer in the Federation of Law Societies, well known for his expertise in criminal law, and had a big teaching role for others in that field in the 80s and 90s. He's represented so many prominent clients, has been counsel on quite a number of public inquiries throughout the country. And we at the college are really pleased to have his support in the development of this special programming in advocacy each year. And the idea behind it is to support the growth and excellence of students in the competitive moots in particular, but even more broadly to address the challenges of advocates in this era of lawyering. This year's visiting scholar in advocacy is Mr. Justice Warren Winkler, recently retired from the Court of Appeal in Ontario. And I'm going to tell you a little bit about Mr. Winkler. You'll hear more about his own incredible career in a few moments. As I'll always know him, I think, Chief Justice Winkler had his hand in the development of many initiatives at the program level, but also, I think, in very innovative ways in his own work as a judge for a long time. He spent 14 years as a trial judge on Ontario's Superior Court and was then appointed to the Court of Appeal in 2007, where he served as the court's president and as the Chief Justice of Ontario. Now recently retired from his perch at the top of the court system in Ontario, he continues to have a key role in the advancement of justice in that province, and I would say across the country. Through his leadership and support, a new institute, the Winkler Institute on Dispute Resolution, was established a couple of years ago at Osgoode to advance both creative and practical work in the area of access to justice and dispute resolution. I know Mr. Justice Winkler best for his, what you might say, off-roading, his accomplishments as a judicial mediator in some of the toughest and the largest litigation battles in this country are legendary. He is, I would say, both practical and courageous, qualities that we need in judicial leaders in the current age. And as anyone who has either shared a panel or listened to him will agree, he's one of the most colorful storytellers that I've ever heard. And I'm very pleased to turn the mic over to Mr. Justice Winkler to share his reflections on justice and on his career. So, would you prefer to use this, or do you want to use the Would you prefer to use this?
No, this is better. Well, thank you, Makala, for that wonderful introduction. I was hoping it might go on a little longer, but I guess time's a limiter here, and so my swelled head will have to just get by on its own. Students at law, faculty, members, colleagues at the bar, members of the judiciary, Chief Justice, friends and family of Halyk, Mr. Halyk, I'm immensely honored to be here with you this afternoon as the Halyk visiting scholar. I've come to know Mr. Halyk as a preeminent counsel and as a person of profound social conscience. I'm extremely proud to be presenting a lecture that bears his name. I address you today on what, in my view, is the single most important issue facing the legal profession as we enter the 21st century, namely access to justice. The title of my talk is Access to Justice, Personal Reflections. I deliver these remarks as seen through a number of lenses. First, as a lawyer who's been a member of the bar for more than 50 years, as a person who's practiced labor and employment law right across Canada for 28 years, former judge of the trial court for 14, Chief Justice for 7, but most importantly, I've come to know the issue of access to justice as a person who grew up in a small town, Pincher Creek in Western Canada and Southern Alberta, in a family of modest means who couldn't have afforded to pursue our legal rights in a court of law then or now. My personal experiences in those roles over my lifetime have informed my perspective on this very important topic. Soon after I was appointed Chief Justice in 2007, my phone began to ring and I got calls from friends from almost every walk of life. And they had one poignant question for me. What was my legacy going to be as Chief Justice? I didn't really think I was that important to have any legacy as Chief Justice, but to a person, they each urged me that I should pick a topic I should pick one that I could speak about from my bully pulpit as Chief Justice. I should pick one that was a legacy topic for me, and I should pursue it vigorously. The notion that appealed to me was really that of access to justice, because as a Westerner from a pioneer family that had arrived here in what is now Saskatchewan in 1882 by wagon, I had in me the blood of a reformer. My great-grandmother and my grandmother lived in Swift Current during the Great Depression, where my grandma, who was by then a widow, owned and operated the local hotel. The rest of my mother's family were farmers in Manitoba and Saskatchewan, and I heard the word corroborate mentioned over and over again. I think some of them lived there. One uncle lived in Meadow Lake, where my dad said was the coldest place on the face of the earth. And my Aunt Eva lived here in Saskatoon. My father's family were Danish immigrants who came to Manitoba at the turn of the century. So as you can see from this brief history, this is a joyous occasion for me. Coming here, even in this cold weather, is like coming home. So in response to my friend's admonition, it didn't take me long as Chief Justice to find a noble cause. I chose one that touched my heart. I chose access to justice for the broader middle class. As all of you know here, access to justice is about the ability of the individual to pursue her rights against the large corporation or the big government. It's about overcoming a power imbalance when seeking a remedy for a wrong that's been suffered. It's about affordable justice. So let me give you a little background to help explain my choice of this legacy topic. When I was appointed to the trial court in 1993, I was assigned to the class action team. Now, I don't want that to get you too carried away, because the class action team was a team of one, me. So I was team leader over myself, and that gave me lots of scope to work with myself, and from there everything went downhill. At that time, class actions were a new invention in the Canadian legal circles. They'd only been legislated into effect a couple of years before. There was only one other province that had a class action statute, Quebec. It was a greenfield area of the law, which appealed to me. There were very few, if almost any, decided cases. So it was getting to learn as I went along based on experience and dealing with this access to justice issue firsthand. One of the enunciated goals of class actions, of course, is access to justice. And as you know, class proceedings are really a procedural tool that enables a group of people who've suffered a common wrong to seek a remedy together rather than having to go it alone, which we all know in most cases they wouldn't be able to do. So access to justice in this context really meant the ability to commence a legal proceeding and carry it through to judgment. By grouping this large number of individual plaintiffs together into a class, the force of numbers was intended to be an enabler for these people who as individuals otherwise could not afford to take on a large defendant. So when I began then as this team leader of myself, boss of no one, the class action business really took off with the entrepreneurial lawyers. And it was almost no time before I had a docket of 150 or so class actions. Some of these cases stand out in my memory because they emanated from mass human tragedies, ones you read about in the newspapers or you saw on TV firsthand. Let me just pick a few examples for you. The breast implants case, the Walkerton water disaster, the hepatitis C tainted blood scandal, the Indian residential schools cases. Make no mistake, there are lots of other cases on that docket of 150 that I could tell you about here today, and you would know them all. But time doesn't permit. For that, I'd like to do it because it would be good for my ego. But you haven't got the time, and it's coming towards spring. All these cases that I've told you about, the ones I'm not going to mention, the ones that I am, involve serious personal injuries to large classes of people, to large classes of victims. Some of them involve fatalities. The class sizes ran into the thousands. Many of the groups were pan-Canadian in scope. There's a tendency, I think, to pay mere lip service to the stated goal of access to justice when certifying or approving settlements in class actions, because the Class Proceedings Act itself is seen to provide the access to justice element. In other words, once the action started, the goal of access to justice has been met. But as I got to be more involved in these cases, in the certification and the approval of settlements and in the implementation, oversight of settlements, the words access to justice to me took on an entirely different meaning, an entirely different dimension. The reason for this is that most of these big class action cases settle. So it seemed natural to me that the notion of access to justice ought to be enlarged, ought to be expanded upon beyond merely the right to bring a suit. It ought to include oversight over the benefits provided to this class of people, to this class of victims. It was important to me that the claims process by which the victims access their benefits be carefully scrutinized by the court from this perspective. Equally important, the claims process had to be monitored after the court approval to ensure that ready access continued to be made available to the victims. Access to justice is dependent on the victim's ability to access his or her benefits with relative ease. This all makes sense, sounds simple, but it wasn't. So let me demonstrate what I say here by reference to a few of these cases as exemplars. Let me start with the breast implant cases. The breast implant cases, of course, were those cases involving those medical devices that were implanted in people's bodies. They had a problem. They leaked and they poisoned the recipient. They deformed their bodies. They caused irreparable harm to them in so many ways. These cases settled with the manufacturers, and one of my very first cases was the approval of the breast implant settlement case. So there I was hearing this case, green as grass, lawyers in front of me, no members of the class, no victims, and an affidavit from the proposed administrator of the settlement, a vice president of an insurance company. So I looked at this and I had an uneasy feeling about it, and I said to the lawyers, I'm not approving this without this person being here so that I can ask her some questions. I said, well, she's very busy and she can't make it. And I said, well, if she's that busy, maybe they're not going to have to look after this settlement, because I'm pretty busy myself and I've got these questions, and if I don't see her, then I'm going to dismiss this. And, there was a class action fee with a multiplier attached, and they saw that they should maybe reassess. So they said they could get her down. I adjourned, and lo and behold, she showed up a month or two later, and we had a dialogue in court. And I said, this is not going to be like a normal insurance case where you come to this case with an insurance adjuster mentality. This isn't going to be about finding ways to deny claims. This isn't going to be about finding a way to show people how they can't get paid because they haven't crossed the T's or dotted the I's. That's not what this is going to be about. This is going to be about having specially trained people who are going to be sensitive to the problems that these class members have, who are going to understand their state of mind and their state of body, who are going to try and help them get the claims processed, who are going to try and help them get the T's crossed and the I's dotted. And if you're prepared to do that, then I'm prepared to accept you as the administrator. If you're not prepared to do that, I'm sorry, you're not going to get approved. She said, well, in that case, that's what we'll do. And she did it. I approved it. And I continued and maintained supervision over that settlement. What kind of cases did we normally have? The vast majority of cases were people who didn't file their claims on time, and so their claims were rejected. Those would get appealed to me. Every single one of them I approved, late or otherwise. They couldn't invent a reason, I could. So we got their claims all processed, and they got them looked after, and everybody was happy. The next case that came on that's on this list that I've got, not that came on period, but was the Hepatitis C tainted blood scandal. This was the case involving the Red Cross where they purchased blood from prisoners in southern jails who happened to have, in many instances, hepatitis C, with the result that they tainted the blood supply provided by the Canadian Red Cross to anybody in Canada pretty well who needed a transfusion. Hepatitis C does a lot of bad things to you. But basically, not being a doctor, I can simplify it, it ruins your organs. It ruins your liver, for starters, and it ruins a lot of other things, and it ruins your life. So this settlement ultimately was reached with the federal government, and it came on for approval in Toronto in June. And the courtroom was all set up. There was a long line of lawyers who were there to get the settlement approved. The class counsel fee in that case was $52 million. In Pincher Creek, that's a lot of money. It's even a lot of money here in Saskatoon. It's a lot of money in Toronto. There were no people in the body of the court. There were no victims. There were no anybody in the body of the court. There was just a long list of lawyers, all there, signed in, gowned up, ready to go get this approved. In the middle of that body of that courtroom was a man and a little boy. And the man got up after the case had been introduced and was starting, and he asked if he would be allowed to speak to the court. So I asked him to come forward, and he came up to the front with his little boy holding his hand. And he said that he and his little boy were from Ottawa. They'd come down for the day for this hearing, and he said he had been transfused with blood supplied by the Canadian Red Cross. He'd contracted hepatitis C. He'd infected his son with hepatitis C. And the light bulb went on in my head. And I said that I was going to appoint a lawyer for him and for the class, was going to adjourn the case, send out fresh notices across Canada, and the case would be brought on in the fall. So in the fall, when we appeared on the return, the body of the court this time was completely filled. People came from all over Canada. They came by bus. They came by train. They came by car. They hitchhiked. They got rides. They brought their spouses. They brought their kids. And so I invited them, each and every one, to come to the front, not subject to any cross-examination or anything except to be able to tell their story. I had Costco Kleenex there, many boxes, the biggest boxes you can get. They got up and told their stories, held hands with their spouses, held hands with their kids, told about how that they'd infected their family members, how they'd all gotten sick, how their businesses failed, how they couldn't keep jobs, how they couldn't go to work, how they couldn't make a living, how they couldn't see a clear way into the future, and all these things, and the almost insurmountable health problems. And I blew my nose and cleaned my glasses and wiped the tears off my cheeks and bawled for 3 days. 3 days is that's a lot of Kleenex, a lot of bawling, and whatever. And I approved the settlement, and we got down to business. There were 2 other supervisory judges, one in BC, one in Quebec, and we started into work with this. So what kind of problems did we have? Well, just for starters, in the first month we fired the administrator. Had to find a new administrator. What's the other sort of thing that happened, to give you a flavor for what this game was like? I was away fishing on the 24th of May weekend out of cell phone contact, driving back to the city on Victoria Day, and when I got back into the zone where my cell phone started to work, all of a sudden, bingo, bang, and my phone starts coughing. There's millions of missed calls. So I zone in on one, ring up. What's going on? What's the big fuss? They say there's a scandal with the Hep C case. The administrator has mistakenly overpaid $750,000. The CBC know about it. There's going to be a scandal on Tuesday when they run the story. We can't, what are we going to do? We can't live with this. So I said, okay, somebody else is driving, I'm riding, so I get on, this is about Bowmanville. If you know where Bowmanville is, it's like Kerrobert. So I'm about in Bowmanville. I've got till Toronto to resolve these problems, you see. So because I've got the fresh fish for dinner and Ruth is waiting for the fish and everything like that. I mean, we've got more than one problem. I'm multitasking. And so I'm on the phone and I'm jingling and jangling, and the first thing you know, I say, well, look, this is all so much baloney. Give me the president of the administrator. I call the administrator up and I say, you know, look, I've got the solution to the problem. He says, oh, what's that? I say, you pay the $750,000 and everything's good. So we have a discussion, goes on for a little while. As we get nearing into Lytton Boulevard in Toronto, he agrees to pay the $750,000. There's no scandal, there's no story for the CBC because the money's been paid and everybody's happy. That's the kind of thing that happens in these cases. And, you know, so what's the other thing that happened in hepatitis C? Well, I can't tell you how many appeals there were, like literally thousands of appeals. Thousands of appeals. And I did the vast majority of those appeals. And, you know, all this was really in addition. I didn't have any staff. So this was all sort of in addition to my regular job. So what kind of numbers? 14,000 claims approved in hepatitis C, 823 million paid out. A bit of a side story here. We paid out 823 million, and we paid all that money out, and we now have more money in the fund than we had when it started. Now that's a good thing. You know, there's 1.3 billion in the fund now. There was less than that in when the Fed set it up. And so the major issue is what happens to the surplus. But just to give you an example of the scope of numbers we're talking about here, on last Friday, I was in the grocery store shopping, and I saw who used to be my back neighbor at the farm who has hepatitis C. So we're having a nice chat, and he told me a lot about hepatitis C to help me understand it when we would go out for lunch and stuff. You're not supposed to do that, but, you know, I mean, how can you not talk to your neighbor? And so when we were doing the case, you know, I mean, he didn't tell me anything I wouldn't want to know anyway. So he told me that he's presently taking medication. He has to take this medicine for 24 weeks. Cost $180,000. Now, if he were on his own on a farm in Markdale, Ontario, in the back of my farm, do you think he could pay $180,000 for 24 weeks of medication? That's a rhetorical question. I don't think so. That's what these cases are all about. Walkerton water disaster. Walkerton water disaster was that case where in the spring of the year in Walkerton, Ontario, there was a dairy farm that was uphill from the water treatment plant. Now, anybody who lives in the country, lives in Saskatchewan or lives in Pincher Creek, Alberta, or whatever, knows what happens when the barnyard's uphill in the spring from the downhill part where the water treatment plant is. The water ran through the barnyard and ran down the well. Now, there was a problem because the water treatment plant was run by two drunks, two brothers, who had a beer fridge in their office and spent most of their time counting the empties. And they got a lot of things wrong. And so 7 people died. 6,000 people were affected. Hundreds and hundreds and hundreds were admitted to the hospital with bloody diarrhea. I first learned about this problem when I was in Pincher Creek at my dad's funeral, and I had the TV on, and I saw all my friend lawyers in Ontario being interviewed in Walkerton by the CBC, talking about what they were going to do and how they were going to fix this problem and get everything going like hunky and dory. And so when I got back, of course, the class action was filed. There were 7 defendants: the province, the public utility, the engineer, the farmer, the blah, 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 7 defendants, and this thing was defended vigorously, particularly by the province. When I was preparing for the certification hearing at the farm, I had the FACTA set on its side, and you all know who do carpentry work that tables are 30 inches high. The FACTA sitting on their side came right to the top of our dining room table, 30 inches of material on its side. So I got reading, plowing through that stuff, and the thought crossed my mind of the likelihood of these people seeing in my lifetime any remedy or any relief. I thought 0. There would have to be all these appeals. It would have to go to the Court of Appeal. I was only a trial judge. Then they would probably reverse me. Then they wouldn't reverse me after I got there, but they would before. Then there was the thing about the Supreme Court of Canada, and they didn't know where Walkerton was, and there were going to be problems. I could just see this all coming down. And so I'm sitting there in court then the following week on the Monday, and I'm still pondering how I'm going to dig my way out of this problem. I'm so discouraged and so depressed. I can see where this is going, into an abyss. And at the afternoon break in court, eureka, I see the opportunity. So I say to all the lawyers, I'm taking a 20-minute break. I want you to sign a foolscap's sheet, and I want you all to agree that we can have a mediation, and if we do so and it fails, I will not lose my jurisdiction to hear the rest of the case. I came back in 20 minutes, they'd all signed. So we started having a mediation in the library, in the halls. I ordered in pizza, just like the students are eating here, and no pizza for us. I don't trust us to have pizza. And so there we are, and by Friday, we have the deal done in the bag. So it comes on for approval, and it gets approved, and away we go. Now, what sort of problems came out of that? There's a whole other story I could tell you about that mediation, but I haven't got enough time because she says I've got to be finished by 3. So, interesting stories too, but we haven't got time. I can't do anything about it. I mean, look at limitations. So anyway, so here we are with Walkerton. We start implementing the settlement, and first thing you know, the lawyers have drafted the administrative part of it. What have we got? They're going to have every single case reviewed individually, 10,000. 10,000 cases reviewed individually. Guess how long that would take? So we have another mediation, completely redo the whole settlement and put it on a grid. Then we have another problem. All the class action lawyers have taken their fee and gone sideways except for 2. One of them, who has 6,000 cases, has only 1 person on staff, 1 paralegal, and himself, plus his other practice. He's got 6,000 cases. The other one has a similar type of resources, another 4,000 cases. Problems. So I get my law clerk, former law clerk, now helper to me, to go down and mediate these cases. He goes in and mediates them all. We clear up the backlog, bingo, bango, and bongo, and everybody gets their money, and pretty well we're out of there. I don't know how much money really was paid out because it's never been made public. There were, I think there would be enough money there to probably buy a new hospital for Walkerton. I have no doubt there would be. And, on another occasion, I say to my former law clerk / assistant at that point, I think we better, I'm getting some wrong vibes. We get in the car, we go down to where the administrator is, walk into their offices, go in, I start sitting in the cubicles where the administrators are doing their phones, listen to them on their calls, call the management in at 12 o'clock and say, we're starting over or you're gone. We have the same problem as this is not insurance adjuster talk. And they revise the thing and we clean it up and on we go from Walkerton. That's Walkerton. Walkerton basically is over now. It's all paid out. Everybody's more or less happy except the ones who died are very unhappy. But, you know, these cases are sad, they're tragic and everything else. Indian residential schools. Everybody here knows about it. It was in the newspaper this morning, front page of the local paper. This is the case that arose out of the operation of what's known collectively as the Indian residential schools, a program widely acknowledged as seriously flawed, the most serious failure, probably the most serious blight on the history of our country. That case was in my so-called repository of cases on my docket, my 150, for years and years and years and years with absolutely no activity whatsoever. I'd go to the gym, I'd see the lawyers there, I'd say, when will you be coming in to see me as the case management judge on IRS? And they'd say, oh, we'll be in any time. Of course, the year would go by, they still wouldn't be there. I was at the gym more often than once a year. I don't want you to think I was only going that often or infrequently, but anyway, there was no activity. Then a case decided in the Ontario Court of Appeal called Cloud. That broke the logjam, and the case came back. And arduous negotiations between Canada, the churches, and the class council. And throughout this period of time, I was the case management judge, so they would come in and report settlement progress to me at intervals, every few weeks probably, sometimes less, sometimes more frequently. And I remember very clearly on one of these visits, they came in and they said, of course, all the lawyers were there, including the government lawyers, and they said, well, we're making progress. We've agreed that there will have to be court approval by 9 courts. I couldn't even imagine that succeeding, frankly. I couldn't even, in my wildest dreams, imagine that that could succeed, because all the courts would have to be unanimous. Number 2, the second thing that really caught my attention was the government had to be the administrator of the settlement. So I expressed my views on that, and which were not altogether positive. And lo and behold, they reported back and said they had a settlement. And so I scheduled the court approval hearings, and as the case management judge, and I don't want you to get the impression I'm a self-centered person, but I scheduled myself to go first and have the first settlement approval hearing, and then I scheduled the other ones across Canada at intervals, depending on how I felt about the judge in that jurisdiction. And I don't want you to take all these things too seriously, but it was a factor. So anyway, that's what happened. And so there we are at the first settlement approval hearing, full of lawyers, people at the back of the court, etc. And lady came forward and she asked if she would be able to speak to the court. And I said absolutely she could. And she said about could others speak? I said yes. And she said, well, we were hoping you would agree, we've agreed on time limits. I said, forget the time limits, but you can come first. She was about my age, I would assess, and so I could get more or less the background chronology in my mind. And she came forward to tell her story. And she told about growing up on a reserve in the north somewhere. I can't remember exactly where. She talked about she and her brother being 6 or 7 years old. And she talked about her parents on this particular day coming and getting she and her brother and taking them to the bush out behind their house and hiding them in the woods and telling them not to make any noise and to stay there till they came to get them, and they stashed them in the bush. And they went back to the house, and pretty soon a big black car drove up. And out of the black car got 2 men in suits. One was the Indian agent and one was the priest. And the little kids saw them go in the house. There was all kinds of wailing and shrieking and crying and screaming and shouting and anger and grief and whatever. And after an interval, the 2 parents came and got the 2 kids out of the bush where they were stashed, took them in the house, handed them over to the priest and the Indian agent, who put them in the back of the black car, took them to the residential school. And she told me about walking with her brother, holding his hand and walking up the entryway to the school. And as they went in the door and went up the stairs, there was an arrow that pointed to the left and it said girls, and to the right it said boys. And her brother went to the right like it said for him to do. She never, ever saw him again. So I had a background myself of Indian residential schools. I didn't think anybody else in the room there had ever even seen one, but I had. I grew up, of course, between two Indian reserves, and we used to go there and play sports. And I had my own personal memories about that, and I told her about my first time going there and how I remembered walking up the steps too and going inside, and I remembered three things about that. First, I remember the green paint. Everything was painted green, like that lime paint that the government buys by train car load, and they paint everything with it. It's all the same green. It looks like those key lime pies. My brother and I used to take them at university and put them in people's hair that we didn't like, that kind of paint. The second thing that I remembered about the schools was, I was debating whether I should even tell you this, but I've told other people, so I guess I could say it anyway, the smell of piss. And the third thing I remembered was being in those schools on so many occasions. The food was good, it was warm, it was lit up and everything like that. I don't remember ever seeing anybody with a smile on their face. Not one person. So now back to this case. So there were the two main issues. The 9 courts that had to approve, and there was the issue of the government as the administrator, the so-called deal breakers. So this was a very heated, very, very heated courtroom. I got into a big argument with I usually try to be a little bit cool, but I wasn't very cool. I got into a big argument with the government lawyers. Wasn't very pleasant. I wasn't going to buy this thing about the government as the administrator, and for all kinds of reasons. And the first was the history of the government being the provocateur. I mean, they had a century of causing the problem. Secondly, the perception. They had been a very vigorous adversary in this case. They'd set up their own unilateral program in an effort to defeat the certification that hadn't worked. They'd attempted this unilateral approach. And I had this thought in my own mind that a defendant could never in principle be an administrator of a settlement. I just had that principle view of it, that a defendant could not, should not ever be an administrator of a settlement because of the perception and the lack of independence and impartiality and neutrality. And so I woke up again, middle of the night. Problem. I knew these settlement administrators because I'd dealt with them all in so many other cases. I knew literally all of them, their resources, their abilities, and whatever. And I knew in my heart of hearts that they could not administer that settlement. They didn't even know where Cardston, Alberta is. They didn't know where Brockett, Alberta was. They didn't know where Carcross, Yukon was. They didn't know where was in BC. They didn't know where these places were. They couldn't staff this. They couldn't even find the places, let alone find the people. So I just knew it wouldn't work. It had to be the feds. So I wrote a judgment, a draft judgment, and I approved them subject to a bunch of conditions that you can go look up Baxter, but whatever, and see these conditions. They were all there, and I said the government had to agree to those. Now, in a class action settlement approval, the judge is not allowed to change the settlement. That's the jurisprudence. You're not allowed to change the settlement. You either approve it or you disapprove it. So I came up with I'd done this in Hep C, and I'd done it a few other times, and so I would approve it, and then I would say subject to these conditions, which I always said in my reasons were not material. Materiality is always in the eye of the, I didn't think they were material. But anyway, they accepted it in Hep C. I thought they But some of my colleagues, I can't get into this deliberation, but some of them had some second doubts about my wisdom. Anyway, we did. And lo and behold, they accepted. So then we had to do, then we convened the feds in Calgary, all the judges there, to have them do a trial run on their administration to see if they could do it. We did it for 3 days in Calgary, and they did do it. They proved to us that they could do it. Then we convened the 9 courts in Calgary, and 3 of them by video conference, and we approved the settlement. I still remember the phone call, and one of the territorial judges was on the line, and he said, "Oh, damn, there's a big storm blowing in. Sorry, closing the court, gotta go." And that was he approved. And, we got the job done. So then we thought, you got to be practical. 9 courts have to approve, so we issued a process. I forget what we called them. I mean, the chief adjudicators back there, I don't know what we call them. I forget what we call them, protocols or something. And we reduced the 9 to 2. So we said there only had to be 2 administrative judges. So, you can always outfox a fox. And so we just reduced 9 to 2. And so we had 2 administrative judges, made it work a lot better than the other 7 we kept friends with, and everything worked out good and fine and everything like that. This settlement's known worldwide, absolutely worldwide. This IRS settlement, everywhere I go, it can be Europe, it can be anywhere, the US, they all know about the IRS settlement. They all know how it's administered. They know how big it is. There were 79,000 people estimated in the class, 38,000 IAP, like the independent assessment process applications, 33,700 resolved, 23,000 and climbing hearings, average award 113,000, I think. The number of dollars dispersed in the IAP side of it, $3 billion, approaching $3 billion. On the common experience, $2 billion, so there's $5 billion paid out. But here's the real story here, 107 adjudicators on the IAP, the biggest tribunal, I think, in the history of Canada. And 2 chief adjudicators are right back there. Former Dean Ish, who was the first chief adjudicator, and Dan Shapiro, the present chief adjudicator, and Halyk, who's famous for this ceremony, is or was an adjudicator, and we met in Montreal. And so those 3 people, I think, should get a round of applause for their work in making this historic case a success. So what did I learn about these and these other tragic cases? The number one thing that I learned was that you have to know the class. In these big cases, you have to know the class. You have to know the makeup. You have to know what they suffered. You have to know their current state. You have to know where they live. You have to know the demographics. You have to know what disabilities they suffer from. You have to know the class. That is number one. And I remember saying that at a conference, and there was a professor there from Harvard, and she stayed an extra day just to talk about that. She said she'd never even heard that view ever expressed. So that's number one on your hit parade right there. Number 2, what are their vulnerabilities, their emotional vulnerabilities? What difficulties do they have, number 3, in accessing the benefits, intellectually, physically, emotionally, geographically? What does a settlement mechanism provide in terms of staffing to accommodate these things? Is the administrator neutral, independent, and impartial? Will the administrator be proactive in helping these people access to the benefits that they're entitled to? 4th, is the structure manageable? Do they have a grid, in other words, where you can put people on, get a remedy for them without having to go through each individual person's personal problems? Do class counsel have the necessary resources? We all know that oftentimes they don't. Does the court have the necessary resources? They mostly never do. Does the settlement provide controls for the conduct of the lawyers? Not even going to talk about that one. The victims in these cases have a really deep-seated distrust of everybody. And so when you view the settlement holistically, does it have credibility? And finally, you have to provide a mechanism so the victims can tell their story. You have to do that. And you have to be a good and a sincere listener so that they get the idea that you are paying attention to them. So I got to move along here a little. She says 5 minutes. I'm only halfway through this thing. But anyway, so look at what's the job of a supervisory judge like in these cases? It's like running an insurance company, frankly. It's like running it's troubleshooting, it's making decisions, it's day to day. And so as the cases went along, I got more experience, and then when I got to, this institutional knowledge in the cases, and so when I went to the Court of Appeal as the chief, I took these big cases with me. It wasn't part of my job. I wasn't supposed to do it. I felt an obligation. I felt a duty. I felt a responsibility for them, and I took the cases with me. And then when I got mandatorily retired, which I think is illegal, I had to leave them behind. We'll hear more about that lawsuit, but in the future. So anyway, now So I move along here, and I'm getting to the end of this. You're gonna get a hard copy of this speech, and you can look at it later if you're so inclined. But anyway, they're gonna give that to you. So here was my legacy thing perking along. So I started looking backward and forward and trying to think of other areas of substantive law that I thought had an access to justice problem. And the first one that crossed my mind was wrongful dismissal cases. Power imbalance, right? And so I got to tell one little anecdote. I got time for that, haven't I? So anyway, I get invited to the OBA to do a speech on employment law, and I go to talk about wrongful dismissal cases because I have this nagging hurt in my gut about there's something wrong with the way wrongful dismissal cases are done. I started my speech off with this story. I was now been a judge for I don't know how long. I'm walking one morning at 10:30 in the morning up York Street toward Osgoode Hall. There's a man approaching me coming down the sidewalk. As we get closer, he looks vaguely familiar, but not much, and I'm walking along, I think, preoccupied. He gets right beside me, and he says to me, "Do you still recognize me?" And I stopped, I looked at him, and I said, "Yes, I do. Let's go in for a cup of coffee." So I took him into the hotel for a cup of coffee, got 2 cups of coffee, and I sat down and I said, "What happened?" He said, "Well," then, and I knew, I'd already knew now where I knew him from. He'd been a president of a very large, you would know the name, Canadian company. And he'd been my client, and of course I'd lost track of him after I got appointed to the bench, etc. And he said, so I went to a board of directors meeting just to do normal things, and he said, shortly into the meeting, they fired me. They told me that I didn't need to go back to the office. They took my company car. They said they'd send my things to me. And so I went home. I didn't dare tell my wife and the kids about this, although I had to somehow explain the no company car. But he said the gig was finally up at the end of the month when there was no check. So I had to tell them. I had a little office downtown with one of those headhunter outfits where I would go every day, and I'd concealed that with them for a month, but finally I had to cough up that that's where I was going. I was looking for a job. The elephant in the room was always me looking for a job. But because I was up here at the president of this really large company, I had a very narrow market, and I couldn't find another job. They raised every possible defense, meritless defense. He said the old skags in town, the expense account, the buying out the previous company, lease on the car, all that stuff. You've all seen it in these cases. Everything they could dream up, they raised as the defense. They wouldn't settle with him. And so he couldn't get another job. And so here he was sitting beside me. Why didn't I recognize him? You see, because when he was president of the company, he was immaculate. Blue suit, tall, thin, always his hair perfectly trimmed, confident, proud, capable, top of his game, big smile, Sean shoes, good shirts, blah, 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 looked like $1 million, top of his game. When I saw him on the sidewalk, he looked about 4 inches shorter. He was fat. He had a crappy suit on. He had old man shoes with those big rubber soles so you won't stub your toe. And what was the dead giveaway was the white shirt that looked gray with the turned up collars, and what really blew my mind was the frayed cuffs and the stained tie. and the hair uncut. He looked a mess, the skin sagging. They had destroyed this guy. See, he said they had to move out of the house. He couldn't get a job. He finally took a job as a manager level in some schmucky outfit. You see, they destroyed him. They destroyed his family. They destroyed everything about him, his whole image, the whole man. If you saw the two of them side by side, you would not even know, I can guarantee to you, that they were the same person. You would not even think they were the same person. You would think this was a movie crew with two different people. This was like the two people before and after in a movie. Now, they finally, 2 years later, withdrew all these defenses that were totally nonsense. They dropped all those, dropped them all. They settled for him at a fraction of what they owed him, and etc. That's what wrongful dismissals were about. So what happened? That very night, the OBA set up a task force on wrongful dismissals. They did a formal report. They got a debate going on wrongful dismissals. They changed the culture in how lawyers dealt with these. They did early mediations. They said that lawyers had a responsibility not to engage in these kind of stalling strategies and these kind of meritless defense cases. They said that. I don't know whether that's universally followed, but hopefully it is. And so I think they, at least to some extent, changed the culture in how wrongful dismissal cases ought to be dealt with. Whether cases are really major, grievance arbitration under collective agreements. I did the Donald Wood lecture at Queen's, wrote up a paper on that. They published it, went viral. Everybody debated whether grievance arbitration had gone off the trajectory or not, blah, blah, blah. That's another thing I did. Family law, I did small claims courts, I did family law. I went around the province talking to people about family